Well, good afternoon, everybody. Thank you so much for coming to our webinar. This is part of the OPD Appellate Program um, Appellate Webinar Series, an occasional series that we have whenever we have a topic or a speaker. So if you ever want to request a topic for a webinar, just let me know. Perfect topics, things that are good for a one-off, talking about a particular case or cases or a relatively limited issue, are perfect for a webinar. They're not things we tend to include at our annual conferences because those tend to be a lot more small group focused and a lot more skills focused, less about just dumping knowledge on you. But anyone can survive having knowledge dumped on them for like an hour or so. Um, Today we have a particularly exalted. I shouldn't pump up your. I shouldn't use overwrought language like that. But we have a well-known and well-loved attorney to dump some knowledge on us today, Jeff Ellis, one of our state's top PRP experts. We have the good fortune of contracting with him for the post-conviction program, where he's representing some of our personal restraint petition filers. And we've invited Jeff here today to talk about some recent um, appellate cases, the Kelly and Vasquez cases, which are very important to resentencing, in particular related to Blake issues. So without further ado, I'm going to hand it off to Jeff.
Thanks, Gideon, and good afternoon, everyone. Um, so I'm going to try to make sense of these two cases. I tried to come up with some overarching theme, and the best that I could do was from the Supreme Court's point of view. We decide which rules to apply and when. Because it seems like as soon as you get a sense of where they're going, you don't really necessarily know where they're going. So what I've done is kind of pull the cases apart issue by issue, and I'm going to talk about them in that way, hopefully progress in a logical way. And I'm happy. What I'll do is I'll stop after each section and invite any questions or conversation. But then when I get to the end of the issues, if anybody has any sort of broader thoughts about the strategy behind these cases and what can be done to kind of pull the court out so much from this sort of what seems to be some degree of inconsistency over time. But I'll just sort of start again, going issue by issue, and the first issue that comes up is the issue of the PRP time bar and whether, I suppose one way to characterize it is whether it constitutes a procedural defense that must be raised by the state, and if not raised, is waived. And that framing really comes largely from the federal habeas post statute of limitations, but it also comes out of case law from Washington, which at one point said, look, our PRP time bar is not jurisdictional. And so it's not like a PRP or a 7.8 or another collateral attack doesn't have jurisdiction if it's untimely. It really does become an issue that is part of the litigation. And if it's not part of the litigation at some point, which we'll discuss in these decision, becomes target gone by. So we start with the Kelly case, where Kelly is arguing that because the state didn't argue the time bar, they had waived it. And the majority says, no, sorry, we're not going to go there. Here's the direct quote. 1073-090's time bar is not an affirmative defense that may be waived. It is a procedural pathway for obtaining post-conviction review. And so, once again, despite the fact that habeas and post-conviction rules are very similar, the court's departing from that and basically saying it's going to be the state can raise the time bar, the court can raise the time bar. And if they don't, if the state doesn't raise it, the court can reach it on its own. Um, Vasquez could have fallen into that same trap because Vasquez was also untimely, but he got a little further down the line. And in fact, his case was his appeal from his resentencing. And so at that point, the court said, well, that target has gone by. We're not going to reach back from this appeal to the post-conviction proceeding and find that it's time barred. But I guess for 7.8 or that the state appeals or PRPs, I would not read it in any way, shape, or form as an exception to the general rule. The general rule being that the court can reach it on its own, the state can raise it at really any time that it wants, and the court will likely consider it. Now, there's a really edifying dissent from Justice Gordon MacLeod in the Kelly case, where she essentially says that's the wrong interpretation. It is a raise it or waive it kind of thing. If you knew Justice Gordon MacLeod in her pre-justice days as a litigant, that's an issue that she raised quite often in her PRPs and collateral attacks. And unfortunately, she never got to vindicate her point of view as a justice on that issue. So I guess what I would say with regard to the time bar is I'm still seeing narrow litigation over this. Um, in other words, the courts, I think, the defense of they haven't raised it is gone, but there's an alternative approach which I don't see advanced very often, which is that I didn't get notice of the time bar, which is statutorily required. And what I'm seeing in most cases these days is simply some notice on a pre-printed judgment and sentence with no statement by the judge. And in a lot of cases, that judgment and sentence actually doesn't get to the defendant. Um, Courts have been very, very willing to find notice, at least inferentially, even where there isn't any notice, such as, well, you signed the judgment and sentence. But it seems to me that this is one of those areas where the statute is not being complied with, where there's probably more room for litigation, because if there's no notice, there's no start to the 1 year period. The other thing I would say, just as an editorial, is while it would be wonderful to think that we could remove the time bar entirely, we really, really need legislation to expand the time bar when it comes to the sentencing rules. Most of the time bar is focused on conviction. A lot of our litigation these days is focused on undoing mass incarceration, specifically through excessive sentencing. And if we could just get, an exception that clearly applies to sentencing based on changes in the law or constitutional rules, if you read the Monchke case, which found an exception based on the statute of conviction being the same as the statute of sentencing, and therefore the statute of conviction was unconstitutional, which only produced 4 votes and has been used to sort of crush every similar argument since. You realize how little room we have to navigate with the time bar when it comes to sentencing cases. And, conversely, what a great need there is. So, short answer is that as long as the issue that's up on appeal can only be you can only reach the merits if it's timely. The court can reach the issue and decide whether it's timely or not. By the way, I had filed a motion for discretionary review the day before this came out, saying it's high time that you guys decide whether this is a procedural defense or not. That's why you should take my case. So it's not going to take too long for them to say, well, you got your answer, bright boy, and the answer is no. So there we go with raise it or waive it. Anybody want to pitch in on that?
Um, so actually, I wondered if you could, for those of us who may not be as familiar with the cases, could you give us a rundown of the holdings of Kelly and Vasquez and how what do they change about the post-conviction landscape? What do they tell us that we didn't know before or that was a question before they were decided?
Sure. Well, I think I can better do that when I get through the individual components, Gideon. But but this is clearly one thing that we were told that hadn't been decided previously was can you get to the merits if the state has not complained about untimeliness? Can the state waive untimeliness affirmatively, right? Can they say, you know what, we're just not gonna raise it? And the answer is no. Uh, this is something that the courts have control over. And I will tell you, Gideon, on some level, it really doesn't come as a tremendous surprise to me. I'm not sure I'm supposed to be talking about these things, but I was at the appellate judges conference last spring and specifically talking to them about post-conviction issues. There was a prosecutor there, and of course, all of the appellate judges. And I raised an issue about the time bar and said, in some respects, you can simplify this by simply putting in your court rules that it's the obligation of the state to raise the time bar in response to a PRP. And if they don't, nobody needs to think about it after that. It's essentially raised, if not waived. And before I could complete that sentence, now Chief Justice Stevens spoke out and said that wasn't how she read or thought the rules should be applied. So and now we have the answer there. So I guess what I'm saying with respect to this is, there's no room to argue this anymore, that it's somehow been waived in your case. There are other ways to get around the time bar. Some of those are increasingly narrow. I'm saying that I think I would always want to look at notice, and I realize if you're dealing with an appeal from a 7.8 and the trial lawyers haven't done a good job of or haven't raised the lack of notice, that probably constitutes a waiver. You're probably not going to get that into your case. Um, so that's my take on application of the time bar and what it is. It's a rule that allows the courts to dismiss the case as long as you're not too far down the line.
On this issue of notice, you know, I'm by no means a PRP expert, but I'm not a newbie. I dealt with these issues when I worked for the Court of Appeals, and then I've had contact with them for many years, since the appellate program has always taken a certain number of PRPs. I've never heard of this notice requirement. And I don't believe, I hope I'm not getting this wrong. I don't believe notice is even in the Supreme Court's PRP manual that they publish. Could you talk like where you said that that's actually a statutory requirement?
Yeah. The statute says that and Gideon, what you're saying comes as no surprise to me. That's in part why I'm bringing it up because I don't think it's been, aggressively litigated on our side. But the statute says at the time of sentencing, the court shall inform the defendant of the post-conviction rights and limitations. When the bill was passed, they also had a provision saying for people already sentenced, they shall be informed by posting notice in DOC like law libraries, so their attempt to provide notice. But there's some early case law about that that says no notice, no time bar, right? You got to have notice to start the time bar.
Yeah,
Um,
I just pulled that up. He's
yeah,
not kidding. I've
right,
never
right.
heard of anyone citing this.
So, the way, I mean, at the beginning, the notice was the judges reading to the defendants in open court the PRP rules, right? Or the PRP time bars and the exceptions. Well, there's always an effort to make sentencings go even quicker, which I don't quite understand why that's a good thing. But I guess it's the press of so many cases. And so now what you see are the exceptions to the fact that there's a time bar and the exceptions to the time bar, and sometimes even less than that on a provision at the end of the judgment and sentence. Very, very rarely will you see anybody ever go over that or even say to the defendant, by the way, there's some notice in here that contains a limitation on your right to seek future relief. You really ought to pay attention to that part. And what I have found is that defendants don't always get their judgment and sentence, right? I mean, they know what their sentence is in terms of the number, but they don't always have their judgment and sentence. And sometimes judgment and sentence aren't signed. The signing of a judgment and sentence by the defendant doesn't necessarily mean that they have a copy or that they've read everything in there, because as we all know, these sentencings happen really quickly. So I think it's a largely overlooked area. It's sad that the burden is on us instead of the state to raise it, for us to raise that there wasn't notice. But I say this to the trial attorneys as well, is that this is an area that should be litigated more often. I will also say, sadly, that oftentimes I've had a couple of hearings on this, and much like ineffective assistance cases, oftentimes the prosecutor will go to the defense attorney, despite the fact the defense attorney doesn't have the obligation to explain the post-conviction time bar, and but will often be able to use the defense attorney, trial attorney, as a witness against his or her former client in this situation. But nevertheless, I think we should litigate it more and raise it more. So
And last question, is it correct that the notice requirement isn't present when the defendant pleads guilty?
no, the notice requirement is still there. It applies for all cases. So then the question, it becomes one of exceptions to the time bar, and of course, for Blake cases, one of the exceptions, the one that most people started relying on post Richardson, which I'll get to second, is that there was a significant change in the law that is retroactive and material to the sentence. And certainly Blake constituted a change in the law. Previously, people had been convicted and convictions upheld for possession of drugs. It was retroactive because it was substantive, and that's not really questioned. But then the question becomes one of materiality. And I will say, if you were just a student of the English language and you looked at that exception and you said, well, what does it mean to be material to the sentence? You would probably construe it to mean that it has to have some relationship to the sentence. There has to be some impact. But the idea that it would be controlling or outcome determinative of the merits seems to be a stretch to the word materiality, because you could, of course, write that there's a significant change in the law that is outcome determinative of the issue on appeal. But the courts have consistently now, over the last couple of years, read materiality in an incredibly strict way. And they did so again in this particular case by saying, well, look, Blake didn't change. Blake's not material to Kelly's sentence because the offender score, the offender score changed, but the range didn't, and therefore it's you're unable to show a reasonable likelihood of a different sentence. They go on to say, like, look, if the standard were lower, that the change in the law may have affected a sentence, that would be just horrible. And in response to that, say, well, what's wrong with that, right? May should be enough, but it's certainly not enough for a court that's very concerned with finality. Although I am reminded of the Court of Appeals decisions that came out before Richardson that said, look, a judge might have imposed a sentence lower in the range if the score hadn't been so high, if this conviction were subtracted. That seems to me should have been enough, but the courts clearly are saying it's not material when your standard range doesn't change. And if you look to some of the other cases recently on materiality, again, they are drawing a very strict line that says there really needs to be a one-to-one relationship between the change in the law and your case. And let me give you an example. Monchke says individuals 18, 19, and 20 convicted of aggravated murder sentenced to life without parole are entitled to be resentenced. Individuals who are 21 are part of the same late adolescent class, at least in terms of the science. So did Monchke change the law? Yes. Is it retroactive? Yes. Is it material to 21-year-olds? The answer that the courts have consistently given is no, that it's not. And it's not because they weren't part of the defined class of 18, 19, and 20-year-olds. And so that shows you how narrowly materiality has been drawn in these cases, which is really, when you draw back it's really absurd that somehow Monchke couldn't lead to a 21-year-old saying, what about me? Will you include me in the class? And you never get to the merits because the court just says those cases are time barred and the change is not material. I will say I'm making a couple of assumptions in that because there is a case, my case, Schoenhaus, that's now up at the Washington Supreme Court, which asks whether Monchke itself was a significant retroactive and material change to members of the Monchke class. There's actually an argument that Monchke doesn't apply to the Monchke class. So I'm hopeful that the court doesn't read materiality that narrowly, but certainly they've been moving in that direction, at least previously. The other exception to the time bar that's raised in these cases is that the judgment is invalid on its face. After all, you look at the judgment, you see a prior conviction there that is now void, and you can make that determination from the face of the judgment in itself. It must be invalid on its face, but the court says, no, it's not invalid on its face because, again, there has to be a change in the range, not just the score. The court also dismisses a related argument saying that there's a similar due process right not to be sentenced with an invalid conviction being considered by the judge when determining what sentence, and they throw that out as well. Now, interestingly, although I praised Justice Gordon MacLeod previously for her position on whether the time bar was waived if raised, in Vasquez, she says, look, it's not really a big deal when there's no change in the range. So she was part of the group that signed the Richardson order, and I guess she is still a believer that that's the correct outcome. So if you're above 9 and you don't drop down, or if you had a half of a point and you remove that half of a point, but your range stays the same, you're not invalid on its face, and you're not getting through based on a change in the law that applies retroactively. So that now I think is finally a dead end. I know we've been trying for years to get some action in that arena, but and I'm happy to have somebody tell me what I've missed. But I think we're at the end of that road for range doesn't change. Nat, you got your hand up.
Thanks. Quick question. Does that apply to the weird ones in the statute too? I think I know the answer to this, but like, delivery, for instance, is one of these weird scoring mechanisms where you have these groupings of like, I think it's 1 to 3 and then, 4 to 7 or something, and they all have the same range within those cohorts. Would it be true that if you went from if it is 4 to 7, don't quote me on this. If you went from a 7 to a 6, you're still gonna be in the same trap that Richardson creates.
Yeah, if you're in the same range, doesn't matter, right? Score changing doesn't get you there, range change does. The idea being if the range doesn't change, your sentence is completely justified. If the range does change, then the court implies that there's a reasonable likelihood of a different outcome based on the new range. All right, so let me then move a little bit into procedure in these motions. One of the issues is what constitutes the grant of a motion to vacate. And the courts have taken a pretty good line on this, saying that a motion to vacate is granted when the court schedules or can obviously conducts a new sentencing, but the scheduling of a new sentencing hearing is enough. And there doesn't have to be an actual order indicating that the previous judgment has been vacated. And that goes back to some other cases as well. It came up in the Carter case involving Monschke resentencing. And I think it's important in some cases because a lot of the trial attorneys and sentencing attorneys, when they've been faced with this issue, don't want an order vacating the judgment because that means the guys have to come back to the county and wait in the county until they get sentenced. And so there was this, I think, practice that happened where folks simply didn't enter the order vacating, but just set the new sentencing. So DOC was none the wiser, and there wasn't any order that said the sentence that you're holding on him technically doesn't exist anymore. But the court said, look, that's enough. That's signals that that it's been vacated and it signals that it's been granted. It seems to me as well, when you look at these cases, that if the state really wants to challenge the procedural niceties of a motion to vacate, that they need to take their right to appeal at that point. Hardly something I would encourage them to do because nobody wants to win a new sentencing and then wait for a year and a half while the appeal goes on before they can get resentenced. But if you go back to some of the earlier issues that we've discussed, state does tend to lose its right to challenge the procedure if they get all the way through the sentencing, unless there's been an objection along the line. Next issue. Can we get concurrent sentences for firearm enhancements? Issue that's been bubbling up for a number of years now. Obviously, firearm enhancements are oftentimes the drivers of sentences. I mean, take a look at Houston Sconyers, which was, of course, the famous juvenile sentencing case. But one of the things that was prompted was because of the multiple firearms that had to run consecutively to each other and to the base sentence. And Kelly shuts down this argument and says, nope, you cannot run firearm deadly weapon terms concurrently. No way, no how. It's not something you can do by discretion. It's not something you can do that would be justified by the finding of a mitigating circumstance, justifying an exceptional down. The state participation or silence is not enough for them to have waived the issue. They don't have to object. They can prepare an order that says these terms are running concurrently, and it still can be raised on appeal. I mean, maybe if they actively seek concurrent terms themselves, but I don't see how they would do that under this situation now. I would say editorially wise, once again, this would be great to have some legislation to change this. I know there's legislation pending again this term, as there has been for, I think, probably the last 3 or 4 terms. But the courts are not going to rescue us here. I would add only that I do think there is some room to argue that the mandatory terms are unconstitutional because they violate the cruel punishments individualization requirement. That's even more true if you've got multiples of them that are stacked on them. And then you have some group which by its definition is less culpable, like children or late adolescents or folks who suffer from severe mental illness. There may be some room to argue that the mandatory terms of the firearms, like I said, especially when stacked on top of each other, are unconstitutional as applied. Brooke?
I just wanted to ask to make sure my understanding is correct. So as far as the mandatory firearm terms running consecutive, that's just for people that are over 18, is that right? But under 18, the court can run them concurrently or concurrently with the base sentence. Am I understanding that correctly?
You are understanding it correctly. Yeah. With juveniles, Houston Sconyers says the constitutional overlay means that any standard range is advisory only, doesn't constrain discretion. And likewise, there's no mandatory term that is mandatory. They're all made discretionary. So firearms for juveniles are discretionary. Now, Houston Sconyers does an odd thing by saying, then in addition, we're not saying that the statute, the firearms statute, is unconstitutional. We're just saying that it has to be construed in light of juveniles' unique place, constitutionally speaking. Children are different. And so we're not striking the firearms as unconstitutional. Now, one wonders, like, how then do judges get there? A mystery that's heightened by Kelly, right? Because Kelly basically says there's no device within the SRA that allows you to do this. I would say in practice, I don't see it as a big impediment. Most trial judges understand when the issue is properly briefed that they have discretion in juvenile cases to run the terms or run the enhancements concurrent with each other. But I'm not quite sure how the math all calculates out. And frankly, I would have preferred that Houston Sconyers says, and therefore we're striking the mandatory nature of the firearms as unconstitutional as applied to juveniles, much like that Miller does for mandatory life without parole, or Monschke does for mandatory life without parole for late adolescents. But that's not what they did. So, but again, I don't see any room. I don't see any argument that was left out, statutorily speaking, that gives us the opportunity outside of the group of juveniles to argue that that the court does have the discretion to run these things concurrent. So we're at about 12:38, and I've given you all a lot of bad news from these cases, but there actually is really good news from Vasquez, which reaffirms what we'd hoped was going to be true and had bubbled up in some of the Court of Appeals cases, which is that once you get to a resentencing and you're doing the resentencing, it is de novo. And de novo means all previous bets are off. The court is not bound by the prior decision. It can consider it, but it's not bound by it. No party is limited in the evidence that it can present or the arguments that it can make, and the judge is not in any way restricted based on what happened previously in deciding what to consider and how to weigh it and what sentence to impose. And one of the great things, especially for de novo, for so many of these cases, is oftentimes we're coming back with individuals who've done very, very well in prison, and the state would oftentimes make these arguments of, well, you can't consider that because that's all post-crime conduct, and so it doesn't really count. So lop that out, or in other cases, the state would argue, well, look, um, this is a minor change. You really need to give great deference to what the judge previously found. And so just because the range changed a little bit doesn't mean you should do something to upset that judge's original calculation. In fact, there are a number of cases, and I believe in Vasquez that one of the arguments was you can just sort of readjust the math, right? Like this is not a sentencing hearing. This is a math problem, and you can just readjust the math and lower the sentence proportionately. And there were a number of cases in the very early days of Blake, rightly or wrongly, where that's what would happen is the courts would simply lower the sentence based on the lower range, and then sort of if it was in the middle before, we put it in the middle now, and here's your new sentence. There also had been an argument that there could be something, I think that was being called a partial resentencing. And I think some of the justices were interested in that idea. But ultimately, that got rejected, and the court said, there is no such thing. The SRA says there's a sentencing or not a sentencing, and if there's sentencing, then it's a full and open road. Um, I will say there, even though not raised in this case, there does become a very complicated issue that where the lines of precedent are contradictory, that involves the intersection of Blake and Blakely. In other words, what happens when an offender score and range are changed, but where there was an exceptional sentence previously imposed prior to Blakely, prior to the rule that said a jury had to find the aggravating circumstance. And there's a wide range of cases out there. In some cases, the judges simply say that aggravator remains in place and authorizes me to impose a sentence above the range, even though not found by a jury. The statute suggests that the opposite course, which is that a jury would have to be impaneled, but only if the aggravator found previously is on the current aggravating list. And then there's a question of how closely they have to match. So I'm not sure that Vasquez tells us that much about that issue. I mean, one would like to think when they say it's de novo and all bets are off, that means that a judge found aggravator that's never been charged, right? Oftentimes there was no notice given prior to the imposition of that aggravator, that aggravator would be wiped out, and there would be, at most some question about whether it could be alleged now and proved to a jury. But for now, Vasquez tells us in situations other than that, it's all de novo and starts all over again. So those are the issues, what they all mean, and how to make sense of these disparate lines of when an issue is reviewable and not. I'm happy to open up to conversations, and likewise, if there's any sort of insider views as to either these cases and the strategy of how they were framed and argued to the court, that's beyond my knowledge. So I'm happy if folks want to talk about that as well. But otherwise, in the remaining 15 minutes or so, let's open it up to discussion and questions.
So I might be asking you to peer into a crystal ball a little bit here, but is it ineffective assistance post Vasquez to fail to present mitigation, new evidence about rehabilitation, and fail to ask for a sentence reduction beyond the removal of Blake points?
Well, I think that it is, but like all IAC claims, it's going to have to be raised in a PRP, and there will have to be evidence presented in the PRP, competent evidence of that mitigation, and that evidence has to convince a court that the court would impose a lesser sentence. And exactly how the Washington courts are going to respond to whether an attorney is deficient for failing to put on some category of mitigation, right? Failed to present something is, I think, an open question. My frame of reference comes from the capital cases where the courts were incredibly forgiving of attorneys' failure to present evidence. Now, that may have been the product of the fact that they were death penalty cases, at least when I was litigating at a time when the death penalty was largely approved, right? But certainly getting the opportunity to raise IAC for failing to present some category of mitigation exists. And I see that Mick has his hand up, and maybe it's on this topic as well. Mick?
You got to unmute yourself.
Oh boy, that took a lot of effort. Sorry about that. I know there's a Division II case, State v. Gore, that somebody did an excellent job litigating an IAC at resentencing claim. It was not I don't believe that was a Blake case, but I could be wrong, where the successor counsel did not seek an exceptional down but it roughly lacked or even a basic understanding of the facts of the case. I've had success raising IAC at not at resentencing, but at sentencing in a non-capital case to get a new sentencing hearing. And my understanding is that Kim Ambrose, maybe somebody in the room knows this for sure, that she took on the representation of Tenelli Anderson after the terrible state Supreme Court decision on his case, and then managed to get him a positive result even after that by developing an IAC at resentencing claim.
Follow-up question. Do you have an opinion on whether Vasquez is retroactive?
In what respect?
I mean, if somebody was resentenced prior to Vasquez and
Yeah.
they didn't have mitigation and so on presented, could they in a PRP argue, well, I should have, Vasquez applies to my case, right? Even though
Right.
maybe it was not clear when I was resentenced whether or not the judge had to consider this evidence.
Right. Interesting question. Here's how I work through it, and I'm happy if anybody wants to add to or gently correct me. Um, Certainly, if a judge said your sentencing is limited, right? It's not de novo. It's much less than de novo. I'm giving, I'm not going to take that thing off the board. I'm going to leave that in place, or I'm deferring to the judgment of the previous sentencing authority, and you're going to have to prove to me that it's wrong. So something that suggests that you're not starting anew. It seems to me that has a substantive quality to it, right? It's akin to a judge saying, I'm not going to give you an exceptional down because that's not a mitigating circumstance. And we know when the court fails to exercise its discretion, that reversals happen, right? So I think that part of it is if you've got a case where the judge says this isn't de novo, it's less than de novo, even if that's that happened more than a year ago, I think you can argue change that's material to you. Now, Gideon, you framed it in an additional way, which is sort of like, well, what happens if the defense attorney simply thought, well, this certainly isn't de novo, but there's no elucidation of that. Um, I mean, I think that's a little more difficult. I would want to have sentencing counsel say, I believe that this wasn't de novo. Were there cases out there saying that it's not de novo? Because that seems also be the distinction in terms of deficient performance based on your understanding of the law. If you simply didn't correctly predict where the law was going, then you're shit out of luck, right? If, on the other hand, there had been some law that said that you relied on that was explicit, then you could argue the change in the law. And I'm sorry, I don't remember right now whether there were bad cases out there saying that not de novo, limited, right? Not just that it was an open question, but that it had been answered in the negative.
Yeah, I'm, multitasking, looking at Vasquez here, and
Yeah,
from what I'm seeing, all the cases, the court seems to say all the cases really align on this, that
yeah,
there's no such thing as a limited resentencing, and there never has been. So resentencing means resentencing. This is a little bit, it's interesting that that was necessary to have. Well, I think it just is indicative of the approach that prosecutors have taken to Blake. Let's find ways to limit it, right? And
right.
that's why this came up, not necessarily because there was strong precedent saying this is a limited resentencing, but because prosecutors wanted to make that precedent and
Sure, of course. But the countervailing interest, and then Ann will get to you, is that if you remember, even though nobody had ever received an exceptional down for being a juvenile, and in fact there had been cases that said the juvenile brain maturation has nothing to do with serious crime. I mean, after all, these are not just flights of juvenile fancy. But then the court said, yeah, but we'd never expressly said no. And so there was no change in the law, right? That's what Lightroth said. So the change in the law really has to be from going from an express no to an express yes, and not just we're not sure, and prosecutors argued otherwise. And again, I apologize. I just don't remember if there was really bad law out there or just the threat of bad law. Anne?
Yes, hi, thank you. I just reviewed a case for a 5046 applicant recently, and he went back for a Blake resentencing, and he started, I'm not sure, I'm sure you need more detail to be able to know this, but he began, Mr. Lee, the defendant, began to talk about circumstances like mitigating factors regarding his history, his traumatic brain injury, etc. And the judge interrupted him right away and said, I've heard this before, yada, 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 blah, 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 blah. Let's get to it. I'm not going to change anything, and basically put a sock in it. I have the transcript. That's why I'm saying this. So, um, you know, specifically. So in that case, so he never filed a direct appeal. Um, so he could file, it would be untimely, but they didn't advise him correctly on his right to appeal after a plea. So he could file a notice of appeal, it'd be untimely. Do you think that would be the appropriate path for seeking review of that half-ass resentencing?
Yeah, I do. And first of all, I'm heartened because that in Kelly, the simple sort of statement at allocution of, by the way, I had a developing brain, you should take that into account, wasn't reviewed as, is there sufficient evidence to support this right now? It was part of the background picture, and it said, let's go do this de novo. All bets are off. You guys can present whatever you want. And so, that's if when you're restricted in that way, the courts have viewed it not so much of does the evidence result, if true, result in a different outcome, but simply adopt that sort of automatic prejudice standard of you were restricted or the judge viewed their obligation as too narrow. But I also think, and we need to find a good vehicle for this, there's this slippery language in a lot of these resentencing cases, especially as it applies to folks who have been recognized to have reduced culpability, juveniles and late adolescents, but you could also include folks who suffer from significant cognitive impairments, intellectual disability, severe mental illness, or even, on the other side of the spectrum, dementia, that we let the judge determine if it's mitigating or not. And I don't think that's the entire equation. And I'd love to see it sussed out here because you can't say that a juvenile who is impaired in some way due to neurodevelopment, that's not mitigating. It is mitigating. We've recognized it as mitigating. It has mitigating weight. A judge has to give it some mitigating weight. Now, we'll defer to the judge in terms of how much mitigating weight to give it and how to weigh it against the other factors. But, Anne, you're absolutely right. We still hear judges saying, it doesn't make any difference to me, right? He knew right from wrong.
Right.
The standard, by the way, okay? And so what judges are saying is, I'm not going to give, I don't recognize those facts ever as reducing culpability. And case law simply says otherwise. And I do think we've got to find cases and start drawing that distinction. To me, that is also the failure to exercise appropriate discretion. And I know the courts have been unwilling to sort of say, this evidence was presented, the judge treated it as not mitigating in any way, shape, or form, but it is. We're not telling you how much mitigating weight to give to it. We're not telling you what sentence to impose. We're not telling you whether you have to impose an exceptional down based on this or something like that. But you have to give it mitigating weight. You have to recognize. And you're using the wrong standard, by the way, right? It's just reduction of culpability. It's not substantial impairment. It's not inability to know right from wrong. It's simply some reduction of culpability based on some impairment or some deficit that is the result of not being a fully mature brain. So I want that case. Okay.
Cool.
That to me is an exciting case, although it's gonna take a really attentive court, some really good briefing, a really good record by trial attorneys, and probably some really bad statements by a judge. Brooke?
Yeah.
I don't know if this would be helpful, but I'm wondering if in Anne's case, you could raise a denial of allocution argument. I recently raised this on a case and it's up for the court right now because I didn't have anything else to raise. But if the court doesn't allow the defendant to allocute, they are entitled to a resentencing in front of a different judge. That doesn't get that doesn't get you in as far as I guess maybe the preservation or the timeliness issues, but it might be a substantive issue that could get a resentencing in front of a different judge. You might have to approach it like an ineffective assistance of counsel claim since his attorney, it sounds like, didn't raise it at the time. But there is case law that talks about if the judge says what the sentence is going to be before the defendant allocutes, they're entitled to another judge and a sentencing in front of a different judge. So I don't know if that's helpful or not.
Yeah, that is
Okay.
helpful, Brooke. And it also goes, I think, to Gideon's question earlier as well, which is, if you've got a judge announcing this sort of restricted approach, either A, they will have really negated the value and the procedure that's associated with allocution, which is you say your piece before the sentence is imposed. But also in some of these cases, the judges where they've adopted this restricted approach, the judges don't consider allocution. I have a case on appeal where the judge was like, "I'm not resentencing you and I'm not going to wipe out the aggravator that was found by a judge previously prior to Blakely. I'm just going to apply the mathematical formula that I think the judge applied previously because your range does change and does drop down dramatically, but I'll use the mathematical formula and then I'll just give you a new number. And, you can't present any evidence. You can't allocate, none of that. And my client, made sure, he said to me, make sure you raise the issue regarding the denial of my allocution, which is I think a great way to get in there and say, here's the best illustration of why this was a less than de novo resentencing. In fact, it was a resentencing without any of the procedural due process that's attached to sentencing. But again, that all gets tied up into the sort of the undecided Blakely meets Blake world, which I think is probably not too far away from getting decided. I know we're at 1, but any final question or comment?
I just wanted to clarify. I asked maybe a weird question at the beginning about right to notice of PRP deadlines and guilty pleas. And that's because I was multitasking. I was like so blown away by this notice issue. I was looking it up, and there's apparently a case and a court rule for limited jurisdiction, which exempts courts from notice of the appeal rights and post-conviction rights on a sentencing in a court of limited jurisdiction. It doesn't appear to have been overruled. So that's the basis for that. But I think you're absolutely correct that as far as felony sentencing goes, the notice is simply required by that statute.
Yeah, and I'll add, Gideon, it seems that in the world of appeals that are otherwise out of time, more than 30 days, where you file an appeal and you didn't appeal before, in part because the appellate courts have been either granting that motion or remanding for an evidentiary hearing. The state seems to have moved to the position of asking for an evidentiary hearing and then in guilty pleas trying to illustrate what a great deal they gave, and therefore you can conclude that this person didn't appeal not because they didn't know their rights, but simply because they were really happy with the deal at the time. So the challenges to the PRP notice of the time bar could also follow with this, now burgeoning interest in doing evidentiary hearings in the trial courts on timeliness and notice issues.
Right. You have a potential lack of prejudice there. Yeah.
Exactly. Yep.
All right. Well, we're at time. I want to thank you, Jeff, for coming to speak with us. Thank you, everyone, for attending. Again, this is an occasional series that OPD puts on related to appellate issues. Post-conviction issues are also welcome. Of course, simply contact me if you have a request for a topic. Even better, if you would like to speak on a topic. I've never once said no to a CLE speaker. It doesn't cost us anything. We're more than happy to do the CLE credit request for you. You can get burgeon your reputation, fame, and glory by speaking to your colleagues about an issue. I'd love to see more of these. So please don't hesitate with the requests. If you want to volunteer someone too, I'm happy to ask them to, if you know who would be good to talk about something, I'm happy to make the request. Everyone have a great rest of your Thursday. And I will see you all soon.
Yeah. Thank you all. It's been a great privilege.